prosecution. And on that basis, I think we advised them that she would not take up the offer of an inquest. We thought that was a way of them escaping their own responsibility to do the right thing.
And then we know from the affidavits of advocates Visi Pakoli and Anton Ackerman, who are both going to appear before this commission at some future date, that there were a few cases which had already been investigated, less than a handful, and they could proceed with them. And one of them was the attempted murder by poisoning of the Reverend Frank Chakani. And that ultimately resulted in a plea and sentence agreement in 2007. Which appears to have precipitated in quick order changes at the NPA. Can you indicate to the Commission, your response to that plea and sentence agreement and what then transpired?
I think we were, quite shocked that the plea bargain was going to take place, and I remember having this conversation with both Vusi and I think it was Anton Ackerman and Tari Pretorius, because I think the question I asked them is, so there's going to be the plea bargain, but have any of them actually offered up the names of those who were responsible for the planning and authorization? And they said no. And that surprised me, because at the end of the day, what were we actually securing? I also remember going to court on the day that the plea bargain was going to be confirmed by the court. And what struck me, and I think I was quite offended by the fact that the judge, obviously, who came from the old order, under his breath, he was muttering all the time about, these guys shouldn't be here before me, because he didn't actually think that they should, in fact, have to make this plea bargain. I also remember the foundation asking for a transcript of the record, because I was hoping that we would be able to pick up from that what he had said, and we weren't able to do that. But I do know, coming out of court, that I had quite an altercation with Advocate Tari Pretorius, because I thought that this was cheap, the way in which this deal was being done, and that it was not going to advance any of the objectives of accountability. They were getting off scot-free. And later on, when the president set in motion his presidential pardons process, all of the guys who plea bargained actually were on that list for a pardon. So it gave you a sense of how awful the deal was. But yeah, I think it was only much later that I learned that even the plea bargain had caused so much problems for Vusi and Anton Ackerman in their office, and that Anton had got this call from Jan Wagner, who represented most of the security branch operatives, informing him, in fact, that he would not be able to carry on with the case. So, yeah, that was my reaction, actually.
So that plea and sentence agreement was concluded in court on the 17th of August 2007. Commissioners, it is set out in the Colata affidavit at paginated page 108. Ms. Suk, it will be the evidence, I believe, of both advocates, Ackerman and Pakoli, that was the best they could achieve in that climate at that time, which was, in their view, restrictive. And indeed, just weeks later, on the 23rd of September 2007, Advocate Bokoli, who was then NDPP, was suspended from office by President Mbeki, and Advocate Ackerman was relieved of his duties in relation to the TRC cases by the then acting NDPP and chair, and that is set out in their different affidavits. It's summarized on page 112 of the Kalata founding affidavit. So that then brings us to the end of 2007, when conditions have changed quite dramatically.
Yeah.
And both Advocates Bokoli and Ackerman are now effectively off the scene. But you and the foundation continued your efforts post 2007. Do you recall whether anything changed, whether in the years 2008, 2009, 2010, investigators were provided to the Simelane and other cases?
No, but the period was also, I think, when we just finished with having the guidelines set aside, when the president decided to use his presidential pardons process, in fact, to give perpetrators another opportunity to get off scot-free. And he announced a special pardons process for people who were convicted of political offenses and who had been denied amnesty. And the reason he said was to resolve the unfinished, he used the word, the unfinished business of the Truth Commission. Now, the president, I think, appointed Dr. Tertius Dalport to chair a committee, and I think each political party had a representative on that committee. What was interesting was that we engaged with Dr. Dalport to try and get him to meet with us and civil society, and he refused. He also refused to make the terms of reference for his committee available. I think we also asked him for the list of persons who in fact had applied to be part of this political pardons process. I think finally through a leak we were able to secure the list, and I think there were 2,300 names on that list. We finally did meet with Mr. Dalport, and when we impressed upon him that even the amnesty process had allowed victims not only to have a voice, but to be part of that, and in fact to have legal representatives to cross-examine perpetrators, and in fact that they were very much a part of the process. It was very strange then that he was not going to allow any avenue or opportunity for victims to have any role in the pardons process. And it was important that he consult with civil society to take into account their views. He was dead against that, and it was quite a difficult process. And so, again, I think it's around March 2009, we supported an urgent application to interdict President Mbeki from using the pardons process. And again, we had to argue that the special dispensation that the president was using was again an impermissible rerun of the TRC's amnesty process. Only in this instance, it was being done quite secretly, and it went further by excluding the participation of victims. And thankfully, in April 2009, I think it was Judge Sisi who granted an interdict and prevented the president from using his presidential pardon discretion. That was, of course, followed in 2009 by Ryan Albert, a member of the Avia Beer, approaching the Concourt to overturn the interdict on the political pardons. And interestingly, in this application, he was joined by President Zuma. Now, it does make you think about the role that is being played by these two presidents in dealing with the political, these cases of apartheid era political crimes. In February 2010, the Concord ruled that no political pardon could be issued without first affording victims a hearing. And, one of the strange things, and I remember that, Kulamani and the Center for the Study of Violence and Reconciliation, they went through that list quite with a great deal of detail. And they found that there were people on the list who had not even applied for amnesty. And so it was such a bogus process, but I think that was a problem. So in that period, you have, on the one hand, the political process trying to give perpetrators another opportunity. And in the same period, I think we weren't able to get any investigators. And so you had no notion of being able to do anything around the TRC cases, even though we were knocking on the doors of the NPA. And I think it's around 2012 when we take the decision that we probably...
Just before you get to 2012, Commissioners, the process that Suka has been describing, there's an overview of the special dispensation on political pardons, and that's provided in the Kalata affidavit, that paginated page 116 from paragraph 289 onwards. And this was essentially to accommodate those individuals who had not applied for amnesty, to somehow ensure that they would not have to face justice if they were given a pardon. Ms. Suka, what's your response to the fact that the reference group of these politicians that had been set up by President Mbeki refused to disclose the names on the list of applicants, and that when eventually it was secured through a PI application, you and your colleagues discovered that people like Ferdy Barnard, a CCB operative who murdered Wits academic David Webster, former apartheid police minister Adriaan Vlok, and former Police General Johan van der Merwe, and the three co-accused who'd received that plea bargain, and then AWB members who'd gone on a rampage in Kuruman in 1995, violently assaulting black people and killing one. These were the people applying for amnesty, and that your organizations were not permitted to make representations in that regard.
I mean, we said quite, at the outset that like one of the rubrics really of the new constitutional democratic order was the consultation with civil society, and certainly in this instance, because it involved political crimes of the past, that victims and their families should have the right to have their views taken into account by the committee. But the notion that firstly the committee didn't want to meet, and they were compelled to meet later on because of the public pressure, I think that in itself was shocking. The second, that they didn't want to make that list available to us. And you will remember that even before the PIA application, there were already media leaks around the names of people who are on that list. And so when we did get the list, I mean, that was scrutinized in a great deal of detail by Kulamani and the CSVR. And I think what was shocking to us was finding all of these people on the list. I think what was appalling, and it gives you a sense of the the challenge around impunity. You have Adriaan Vlok and co. making a plea bargain in, 2007, And by 2009, they're on a list where they're going to get a presidential pardon. So what was the punishment there? Where was the accountability? And it gave you a sense of the absurdity of what you were dealing with. But I think it also raised another important point, and this was the level to which those in political power would go to afford perpetrators another opportunity to get off scot-free. And I think it began to make a mockery, really, of the process of the Truth Commission, because in effect what you were doing was entrenching impunity in the country, and at the same time, there weren't that many opportunities for victims, and even the reparations process was in fact quite slow to get off the mark. So when you compared the two situations, I think perhaps already there was a sense that the state was going to turn over backwards to give perps another opportunity to get off.
And talking of political power, when President Mbeki announced in Parliament the establishment of the political pardons special dispensation, he said it would remain true and faithful to the principles and standards of the TRC. So it would work in the same manner that the TRC had worked. And yet he was more than happy to make decisions coming out of the reference group that were entirely one-sided, only heard from the perpetrators and nobody else, not the victims or the communities. What does that say about the political approach to this process?
It's a political approach that I think from the outset has favored perpetrators, I think to the detriment of victims. And remember if you go right to the beginning when the amnesty process was crafted, South Africa also had to defend its position at an international level. And I recall that, Diale and Professor Medard Rowela-Mira, they were also participating in the discussions and the finalization of the Rome Treaty. And there was this conference in Syracuse. And Diale is very careful because he talks about the way in which the amnesty process has been calibrated, not to just let perpetrators off the hook. The way in which the amnesty is framed is conditional, so that upon making a full disclosure, upon showing that you committed that act in pursuit of the objectives of the state or political organization, and the fact that victims were in fact allowed to participate in the process, it would be a public hearing if it involved a serious crime. Victims had the right to have, to object to it. They had the right to say that they didn't want it to happen, and they could cross-examine perpetrators. In many ways, that introduced some legality into the process. The fact that the criminal justice system remained operable, and that once the amnesty process was over, the criminal justice system would take over. I think that, in a way, provides the balance for the restoration of the rule of law in a time when you have this extraordinary exception. But now you have the continued attempts by the state itself to actually destroy that. You have first the question of the amendments to the prosecution guidelines, impacting on the ability of the NPA's independent decisions to prosecute, depriving them of the resources even then, which would enable them to do their work properly. Once you have those amendments set aside, you then have this reversion to pardons, using that kind of political power to set up a committee that will make decisions which have far-reaching implications for the lives of victims in our country, and you don't even afford them a voice. That is a complete annihilation, really, of the constitutional order and democratic accountability that we were building in our country. So it was appalling, but it was giving you a sense already of how far the state was prepared to go. I think what was striking then was that when Ryan Alberts applies to the Constitutional Court to set aside the interdict, he's joined by another president. And so those two names feature constantly in this trajectory of 30 years of impunity in our country.
So you were saying that investigations of the TRC cases were held in abeyance in the subsequent years, and we know from the affidavit of Advocate McAdam that the attempts he made post-2007 to obtain investigators, he was told by the police that they wouldn't investigate while the Diale Commission was ongoing. And then when that was done, then along came the World Cup, and he was told that while the World Cup was busy, because that placed big demands on the police, they wouldn't be investigating the TRC cases either. So what ultimately did the foundation decide to do? Because you were probably at your wit's end by that point.
The first thing we did, of course, was to, it was clear that we were not going to get investigations through the NPA or, the SAPs at the time. And so we decided that we would retain the services of Frank Dutton, who had worked for the Goldstone Commission. He'd also been part of the Scorpions, and he had a really good understanding of this kind of work. And we brought Frank in, firstly to work through all of the amnesty applications, and in fact to give us some advice on how we should proceed. And secondly, I think we also brought him on board to begin to look into the Nokuthula Simelane case. And I mean, Nokuthula's case was very interesting because, at the time, and I'm sure you will hear from him, but at the time when, you had the amnesty applications for the Simelane case, you already had almost a complete docket by Captain Andrew Lees, who had done quite an amazing job, I have to say, before the Truth Commission even began its work. And so this was, the amnesty applications to some extent, I think provide a lot more evidence on the case, but Frank was able to, trace people using Tembe's assistance, and as a result of that, we were able to put quite a good dossier together. But we were forced, actually, to bring on board an investigator to, in fact, begin to do the work that the state should have been doing, actually.
So that comprehensive dossier, was it handed over to the NPA? And if so, what was the outcome?
I mean, it was handed over to the NPA, but even then, I mean, we didn't really get very far on the matter. And I think it's when we, I think, finally make a decision that the only way to secure any kind of progress in this matter is to litigate against the state and, in fact, to compel them to make a decision on the matter. I think this is also when they try and suggest that Tembe should, in fact, go for an inquest rather than a prosecution. And so finally, I think we decide that we're going to bring an application to compel a decision in the matter.
Yes, and we heard also from Minister Thembi Simelane that in terms of the timing at least, is this also your recollection that Frank Dutton was appointed around 2011 and that he submitted his comprehensive report to the NPA within a year or 18 months at that time, but that in the intervening years between 2011, 2012, all the way through to 2014, 2015, because it appeared that there was no real progress. It was at that point that Thembi Simelane, with the support of the foundation, decided to approach the court to compel a decision.
Yeah, that's correct.
And then once that case had been launched, can you just give us a sense from your perspective as to what transpired?
You know, I think the application did shock the NPA at the time, and they'd not expected us to go so far. And you know, I think as councils were discussing the question of how to deal with the matter, I think then the NPA, I'm not sure if he was the acting head, Sean Abrams, actually called, I think, and he was really begging them not to take the matter further. And in fact, he said that the matter could be settled by the NPA agreeing to indict the security branch officials who, in fact, had been implicated in the amnesty application, but had, in fact, not been, not received amnesty. And so on the 14th of March, suddenly the NPA indicts, I think, 4 people, Kutsia, Pretorius, Mong, and of course Khampepe. That's the beginning really of the one of the first cases that we were willing to kind of go towards that direction. Remember that what was also interesting about the case that Thembi brought is that you have Vusi Pikoli and Anton Ackerman filing these affidavits in support of the application. And that is, I think, then that you get a sense of how frustrating it must have been for them behind the scenes. And no doubt they will speak to these issues in their own evidence. But I think for us, it was a shock to get to know how far the state was prepared to go to, in fact, infringe really the independence of the NPA, to allow perpetrators again another opportunity to go scot-free. It just seemed to me that the intention at that point was to interfere with the prosecution's independence, but also to ensure that there would be no investigations and prosecutions. So I think that's the first written confirmation you get beyond the pardons process and the amendments to the guidelines that there was going to be this level of political involvement in the prosecutorial process.
So the outcome of the Simelane litigation, and commissioners, as mentioned previously, we refer to that matter as Nkadiming 2.
Yep.
You seem to be describing that as something of a breakthrough because it resulted in indictments in early 2016. So what was the impact of that case on the other TRC cases?
I think that what it did do was give, it inspired other families to begin looking at what could be done on their cases. And in fact, that is when the foundation was also approached by a number of other families, including the family of Ahmed Timol. Imtiaz Kaji, I think up until that point, had had his own dealings with the NPA, and I think referenced in these papers, you have a sense of how he'd been told at some point that the case had been closed, and so he also came to the foundation to seek assistance on dealing with his case. You also, I think around January 2016, our lawyers, Weber's, in fact, writes to the NPA, to Sean Abrams, I think, and to Tariq Pretorius, and they ask for a meeting to discuss several cases. And this is really on the basis of the report that Frank had prepared on which cases were in fact viable cases to take forward. And so in January 2016, you have Frank, George Bezos, yourself, and representatives from the Timor and Agate families make a presentation to the NPA arguing for the reopening of some of these matters. And so 2016, post the Tembe case, you see, I think, a number of families feeling that they are enabled to, in fact, argue and advocate for their cases to be taken forward. Then, of course, you have the fact that on the Timor case, the NPA also doesn't really do its job. Again, there are a number of delays. And so finally, you have Weber Wenzel representing the Timor family, threatening legal action against the NPA if a decision's not taken timeously to reopen the inquest. And around October 2016, you have the PCLU confirming in a letter that they've written to the Minister of Justice to ask for a judge to be appointed to oversee the inquest. And so finally, I think in 2017, you have this historic reopening of the Timor inquest.
Thank you, Ms. Suka. Commissioners, my attorneys have actually compiled a schedule of communications that various attorneys had with the NPA, placing them on terms, various letters of demands, with making threats that court action would be taken if the NPA did not act. And with the leave of the Commission, we'd like to hand up that schedule.
Yes, you may. What exhibit number should we allocate?
Commissioners, this would be bundle 5. That's Jasmine Suka's bundle, and it would be item 3.
Thank you.
So, by way of example, Ms. Suka has been referring to the Ahmed Timol case. And there are some items here that are not strictly speaking letters of demand, so we won't refer to them. For example, the communications by Frank Dutton. But on the 21st of June 2016, Weber Wenzel sent a letter to the NPA, placing it on terms. A decision was not taken to reopen the inquest. And in the next column, we set out the references in the bundles where those letters can be found. So, for example, that particular letter is in bundle 1, or rather it's referred to in the Lacanio affidavit, and bundle 1, page 135, paragraph 347. And the actual copies of these letters are contained in the contextual bundle that is also on the website. And at the end of the schedule, we give the item numbers where those letters can be viewed. But so, for example, in the Ahmed Timur case, letters of demand or containing threats of action were sent on the 21st of June 2016, 8th of July 2016, and the 11th of August 2016, and then a final letter of demand on the 23rd of August 2016. And similar letters were sent in the Neil Agate, Hussein Hafiji case, COSAS 4, Imam Harun, Craddock 4, Kafia Sanyoko. Chairperson, I see it's 11 a.m. Would this be an appropriate time for the tea adjournment?
Yes. We'll take a short tea adjournment and we'll reconvene at 11:15.
As the Commission pleases.
Mr. Vani?
As the Commission pleases. Ms. Suka, just before the tea adjournment, you made reference to the fact that that you, Frank Dutton, and the lawyers were now having interactions with the NPA. And I want to draw your attention to a potentially significant interaction in January of 2018. And Commissioner's reference to that January 2018 interaction is reflected in the Kalata affidavit on paginated page 158, at paragraph 413, where Mr. Kalata writes that, emboldened by the outcome of the reopened Timol inquest in 2017, Weber Wenzel addressed a letter to the NPA dated 18 January 2018. Commissioners, a copy of that letter is annexed to the Kalata affidavit at FA 66 and can be seen on page 738 of Bundle 1. And that this then resulted in a meeting later that month with the NPA and the DPCI at the NPA. Now, before we get to that meeting, do you have a copy of the Weber Wenzel letter dated 18 January 2018 before you?
Yes.
Yes. Can I ask you just to give an indication of which were the cases that were being highlighted by Frank Dutton through this letter? And you can just, I'm not asking you to read the letter, but if you can just highlight the individual cases. So, for example, on the first page, there's reference to case 1 and so on. If you could just take us through the cases by listing them, please.
Commissioners, the first case that is referred to in the letter is the case of the late Nakatula Simelane. And of course, it's the case where the state has indicted Timothy, Khampepe, Kutsia, Peterser, and Mang. The second case is the case of the late Ahmed Timor. And the third case was that of the late Neil Agate. And the fourth case was that of Matthews Mabelani.
Can we just pause for a second? So by then, in relation to Ahmed Timor, the inquest had concluded. But can you just give a sense from that paragraph 4 why that the team was still highlighting that the Timor matter?
Well, in that particular case, at the end of the inquest, Judge Motley had recommended that the criminal charges be pursued against Sergeant João Rodrigues, Warrant Officer Neville Else, and former Colonel Seth Sons. And so what we were wanting to do through the discussion was, in fact, to engage in discussions on when these charges would be preferred, and in fact, looking at the question of further investigations with a view to prosecutions. So it was really taking the Timor matter to the logical end after having found Rodrigues responsible for his death.
Thank you. Please continue.
Then, of course, we raised the case of the late Neil Agate, and I think the fact that extensive presentations had been made on the Neil Agate case, including with evidence, and really what we were waiting for was when the NDPP would recommend to the Minister of Justice the need to reopen the inquest. We also raised the case of the late Matthews Mabalani, and Matthews Mabalani also fell to his death in very similar circumstances to Ahmed Timor, and we wanted to assess what progress had been made in the investigations to date. The fifth case we raised was that of the late Hussein Mia Hafiji, who died on the 3rd of August 1977 at the Brighton police station in Durban, where according to the police he had committed suicide by hanging himself. And while we understood that the NPA was seized with the matter, we again wanted to get a sense of progress. Then, of course, another case involved the case of the late Babla Suluji, where the police had also, claimed that in 1964 he had committed suicide by jumping from the 7th floor of Gray's building. And again, we wanted to find out, firstly, if the matter was on their books, and if so, what was the status of the investigation. We also asked the NPA to advise if they were seized with any other matters from the TRC lists, and could they give us information around that. Because when we had met with Advocate Abrams after the launch of civil proceedings in the Nokuthula Simalani matter, he had informed us that they had 10 other matters on the go, and we wanted to find out from him which cases they were. We raised with them that Imtiaz Kaji had been in contact with the families of Nicodemus Kwathi, Solomon Madipane, Jacob Manachotla, and Dr. Albert Lutuli, and we wanted to get a sense from them on how they were dealing with those cases. We also raised that there were possibly other cases that they could take up, and the question of Imam Haroon, after we had been in contact with the family who had approached us to take the case up. Then, of course, the case of Stephen Biko, and we wanted to get a sense from them, following our own analysis of the amnesty applications, whether they would take up a number of other cases, and these included the murders of Eustace Madikela, Inshingo Matubingwa, and Fanyana in Shlapo. Also the murder of Sipho Charles Hashi, Kuguli Godolose, and Champion Galela. We also looked at the murders of the Kraddock Four, and then, of course, the kidnapping, torture, and disappearance of Peter Tabuleka, the kidnapping and murder of Intombikaisa Kubeka, the murder of Richard Motasi and Irene Motasi, the kidnapping and disappearance of Moses Murudu, the kidnapping, torture, and murder of Jamison Ngomazulu, the murder of Joanna Sweet Sambo, the murder of Adriano Luis Bambo, and the murder of Welcome Kanyile. And we wrote in our letter that the potential accused in these cases were persons who had been denied amnesty by the Truth Commission, or in some instances had declined to apply for amnesty. We also set out that the 11 cases set out in Annexure A were ripe for investigation and prosecution, and should not have been for so many years, and should have been so for many years. So I think what we wanted to get a sense from them is to discuss each of these cases and the possibility of these cases being handled. That's the time when we began to raise the question of a dedicated team of investigators and prosecutors, because what we picked up in the Timor case, and in fact in our dealings with them around the Agate case, that you didn't have a dedicated team. And so this is the time that we also raise with them the need to begin to look at how to handle carefully selected investigations. I think we were pointing out to them already that if they wanted to have success around the TRC cases, this is going to be a necessary step to take. So we raised it already at that period in 2018.
Thank you, Ms. Suka. Commissioners, the Annexure A that Ms. Suka referred to, reflected in that letter, that was a memorandum compiled by the late Detective Frank Dutton, and he gave an overview of the evidence and potential suspects in each of those 11 cases. It's not part of this particular annex, but we have provided it in the contextual documents bundle at item 17. Now, Ms. Suka, can you give the Commission an impression of how that meeting went at the NPA, where you had senior prosecutors present, you also had senior officers from the DPCI. Did you get a sense that they were keen to turn over a new page and get stuck into all these 21 odd cases?
Let's say I was cautiously optimistic.
But then not so much longer after that, investigator for the foundation brought to your attention that the investigators who were pulled together to deal with those cases, that one, in fact, was a former security branch officer, and one had a possible connection to the Matasi case,
Yep.
which was on the list. What was your reaction to that?
It's the reason why I say I was cautiously optimistic. I think that on the one hand, the NPA was saying that they wanted to do the right thing and that there should be a new beginning. On the other hand, I think the fact that you could still have investigators seconded to work on these cases who were connected to the security branch, and one who was deeply implicated in the Richard Motasi matter, gave you a sense that there was very little vetting and screening that was being done. And we brought this to their attention immediately. But it gave you a sense that the commitment was stated, but it was not really there.
And to underscore that sentiment, even though we know that, for example, the Agate and Hafiji and Harun cases were taken up. If one looks at the schedule of communications placing the state on terms, the one that we just handled up, that's now in Bundle 5, Item 3, we've spoken about the 4 letters of demand that had to be submitted in the Timor case. But if one just casts one's eye over the schedule in relation to the Neil Agate case, there were 6 threatening letters or letters of demand placing both the NPA and the Minister of Justice on terms, and the last one threatening an urgent High Court application in August of 2019. And then 2 letters, such letters were written in the Hafiji case, and in the Harun matter, there were 3 letters, similar letters written as well. What does that say to you about the steps that the families had to take to persuade the NPA and the DPCI to act, that they had to threaten court action in these matters if they did not move forward?
Commissioners, my sense of the NPA and the DPCI was that they were brought kicking and screaming into the process, and that the only time that the families were able to achieve any kind of action was when they litigated or they threatened litigation. And that's the only time that things began to move. I think what is incredibly shocking, and if you just look at the trajectory of the agate inquest, and I don't have the sort of dates with me, you have the NPA, after all of these letters indicating that they're going to write to the minister for the approval of an inquest. But of course, the way they drag their feet, you find in that period that you have one of the key perpetrators, Stephen Whitehead, dying in that period. And it's only after then, that event, that you then have them actually getting that off the ground. And so one doesn't get, one doesn't have a sense of an NPA and DPCI committed to the process of justice for the families of victims. I think the only time that you got anywhere was when you threatened them, and that then produced some kind of result. If you also look at the way in which these inquests have been conducted, to be frank, it's the work that's been put in by our legal team that has really produced the kind of evidentiary basis for judges to actually find that the apartheid state was responsible for the death in detention of many of these activists. It didn't come because they actually did their work. And I think that that's the tragedy of the process, that they would tick the box, but then do everything in their power to actually delay getting on with implementing the necessary actions. It's quite tragic for the families.
And so further examples of what the families had to do, in some cases going beyond issuing letters of demand. So, for example, in the COSAS 4 case, in September 2020, they actually had to launch a substantial application in the Krugersdorp Magistrates Court for the disinterment and forensic examination of the bodies of the COSAS 4, because after much communications, they had been told that post-mortem reports and the like could not be found. And it was only thereafter, after lodging that application, that that case started to move. Similarly, in Cradock 4, in July of 2021, as we heard from Lekanyo Kalata yesterday, they also had to launch a substantial application to compel a decision. At such a late stage, should families be having to take such action when they had been told that the authorities were now pursuing these matters?
It's completely untenable that, in fact, the families and the foundation should actually take on the legal obligations of the state to hire private, investigators to, in fact, compile the kind of evidence that is necessary to proceed with these matters. I think that's a complete and utter violation of their rights. I think what was also quite disturbing for us is that in the intervening period, you had the appointment of a new National Director of Public Prosecutions in the form of Ms. Batoye. And so we were very excited in 2019. I led a delegation of family members and some legal representatives to have a meeting with her. And we were really excited because she advised us, in fact, that she was deeply committed to ensuring justice for the families. The foundation also offered to host a workshop for the prosecutors around the country to give them a sense of what was required in dealing with the cases of the Truth Commission. And we had, in my view, a very successful workshop. So at that point, we were quite excited about the idea that you would have a new era dawning. Unfortunately, it was not to be. And while I think the team worked alongside the NPA team quite well in the agate matter, I can't forget that at one point they were going to argue that, in fact, it was an assisted suicide and not a killing. And I think it was George Bezos who told them that, that's absolute nonsense to go down that trajectory. So you have this intervention and you begin to think that things are going to change, but actually very little does. And I think one of the fatal moments came when I think it was around January, when the national prosecution adopts a decentralized policy, and cases are then farmed out to the provinces with incredibly lackluster results. So much so that if you actually look at some of the submissions we made to them and to the portfolio committee much later on, we raised the fact that under this decentralized authority, there was no real head. And even though they set up what they call this TRC component, which I'm sure we will come to at some point, nobody took responsibility. So if you dealt with a prosecutor in the province and you tried to get a decision, they would refer you to head office, and head office would then refer you back to the province. And so it was like a ping-pong battle with nobody held responsible. And so for me, that began, I think, to show that, in fact, we were no better off now than we had been before. The only thing is that the NPA had shored up. They said they'd set up this unit. It was diffuse in terms of authority, so they were ticking boxes. But in terms of real action, nothing was actually happening. Case in example, and you've heard extensively from Lucanio Kalata, but I recall in 2019 us doing a presentation with the legal team to Advocate Rodney de Kock and his team, setting out all of the persons of interest, all of those who played a direct role in the killing of the crowd of 4, those who were responsible for the planning and authorization, all of that PowerPoint is still available. But you know what happened? Nothing happened after that. And in the end, the family had to resort to an application before a decision was made to move on the case. So it's just another example of no movement, So I would, probably, and this is something that the Commission will need to look at, while there may not have been direct political interference, I think, in this period after 2019, but you have to ask the question of dereliction of duty if you don't proceed with the cases. So many perpetrators died, and so many family members died, and yet these were cases which were ripe to take on, either through a prosecution or an inquest.
So just returning to that list of cases that were submitted, the 22 matters referred to in that January 2018 letter and subsequent meeting. Mr. Kalata, in his affidavit at page 160 of Bundle 1, he points out, and this is at, by the end of 2024, so some 6 years after that interaction, of the 22 cases that were highlighted, only a handful had actually been concluded. And these were the Agate, Hafiji, Diale, and Haron inquests. And since the end of 2024, there have been a few more matters concluded, perhaps most notably the Luthuli inquest. But in respect of all the other matters, they either have not been attended to, or they are still work in progress, and some of them have been long delayed. So when Mr. Kalata, in his affidavit, when he speaks of the period after the Timol inquest, and he says, well, we're not accusing the NPA or any other authority of political interference or being subjected to political interference post-2017, but he says that the impact of the interference has been devastated, and that it still lingers into the era up to today. Would you agree with that assessment?
Yes, I would agree, because it's a complete violation of the rights of victims. So not only were their rights violated by the apartheid state, and in a sense their rights were infringed upon by the amnesty period as well, but then you have the democratic state responsible for ensuring that their rights are upheld and that their right to the truth, to justice, and accountability. Where nothing happens, then the state and its institutions have violated their rights. And there's a question to be asked about whether the impunity of that period has also fed into the overall impunity of the system in South Africa today. I would trace that back to the fact that the institutions meant to uphold the criminal justice system, if you didn't deal with the political crimes of the past, which brought the new state into being, then that begins to impact on everything else that comes afterwards. We shouldn't be sitting here. And we're sitting here because of that endemic impunity.
So from around 2019, am I right in saying that you and the Foundation for Human Rights approached the NPA in writing, and I believe through meetings, with the proposal that the NPA, in collaboration with the police, set up a dedicated or specialized unit to deal coherently with these TRC cases, given that they were old, cold cases and the window of opportunity was fast closing. Can you describe the efforts that you made to try and persuade the NPA to change course from its decentralized approach, which you earlier said was not working that well?
Yeah. I mean, we'd looked at, the success of prosecutions post a kind of truth-seeking mechanism in other countries. I think in particular we looked at countries like Chile and Argentina. And I think we, in fact, found that the success was due to the fact that there was a centralized unit that dealt with these investigations and prosecutions. And in fact, the investigations were prosecutor-led with a special independent prosecutor. And we had done, I think, quite a number of opinions, of comparative research looking at the issue. So not only did we write to the NPA, but I think we also sat down with the NPA to inform her that, in fact, this was a possibility, and this would work well. But what you needed was a commitment to have this kind of specialized unit. And I think we said that in a very short period, you would be able to deal with a number of cases. We suggested what those strategies should be, but I'm afraid that once they had adopted that particular course of action, they were not going to turn away from that. And you see that I think we much later, do a submission to the Portfolio Committee, and I think we have it probably somewhere in the bundle. And we point out how, because you don't have a dedicated investigator or prosecutor, people are busy with so many other matters that they can't pay attention to a particular case, and I think that's been a fatal flaw. You also don't have somebody at the helm who has accountability for the decision making. And if you don't have that, then you have what's happened in these cases, and you can see that a complete lack of attention to what could have been possible in that period between 2019 and now. You know, there have been, of course, some prosecutors who've been incredibly courageous, and I think that, you know, one of them that we have to mention is, I think, Advocate Malachwa, who was here in Gauteng. And, you know, we shouldn't have had to argue the question of prosecutions under apartheid as a crime against humanity. This was another area where we furnished the NPA with several opinions on how important it was to prosecute under that rubric, and that didn't happen. And they fought from head office tooth and nail that the COSAS 4 charges shouldn't be done under that rubric. But Malachwa stuck to his guns, and it's the one case where, in fact, you know, the charges have been preferred under the crime of apartheid. And I think it was last year that Judge Dozio dealt with all of the objections to prosecuting under that rubric, and I think his judgment is outstanding in terms of confirming apartheid as a crime against humanity and as a frame, in fact, for prosecutions in the future. So you have had people who've been extraordinarily brave, but, you know, they stand against what was happening in head office.
Thank you, Ms. Suka. And of course, that, that judgment of Dossier J on the crimes against humanity charges in the COSAS 4 indictment is currently before the Supreme Court of Appeal. Just returning to the efforts that the Foundation made to call for a change in the approach on how these cases were being dealt with. Commissioners, an overview of these efforts are set out in the Kalata Affidavit Bundle 1 from page 173 under the heading Call for a Change in Approach from paragraph 449 onwards. And then, Ms. Suka, it appears that the Foundation in September 2020 presented a memorandum to the President, the NPA, and SAPS and various ministers titled Proposed New Approach to Apartheid Era Prosecutions, and that provided a comparative overview, and you've already mentioned examples from Chile and Argentina where they had dedicated units dealing with these cases. And then at paragraph 452, the Foundation then followed up with a legal opinion in January 2021 titled Exploring Legal Options for the Establishment of a Special Capacity to Investigate and Prosecute Apartheid Crimes, and that was supplied to the NPA and the Minister of Justice. It's not attached to the Kalata Affidavit, but it is in the contextual documents under item 34. And that opinion looked at how, in terms of current law, a special approach could be pursued. For example, the setting up of a special unit under a special director, just like you have for specialized commercial crimes and sexual offences. So it seems that fairly strenuous efforts were made. What was the approach, what was the response from Advocate Batoy and the NPA?
Well, I don't think they were in favor of the proposal. And in fact, I think it was later in that year that they, together with the DPCI, issued a joint press statement in which they announced a new approach to dealing with the investigations and prosecutions of the TRC. And they talked about the establishment of a dedicated capacity, but they certainly didn't adopt the recommendations that we made in the opinion. And in fact, as the experience will show, this dedicated capacity was not really a dedicated capacity at all. So they rebuffed the approaches that we had made.
And just to conclude, the efforts to get a special unit, perhaps under a special director, am I correct in saying that eventually in 2025, after Lekana Kalata and the other families had launched their application, that Advocate Batoy, in a letter to the attorneys, indicated that she was, at that point, persuaded to consider the appointment of a special director?
Yeah, that's correct. Too little, too late.
That correspondence is not currently before the Commission, but my attorneys will ensure that a copy is placed on the record. And clearly, that was welcomed by the families. But what transpired?
Nothing, actually. And she didn't do that. And in fact, when pressed around it, we had argued that this could have been a legacy issue for her. And she actually said that she didn't want to bind her successor. So nothing came from the fact that interventions had been made on the basis of very powerful evidence about how this was working in other countries, lots of discussions around it. And then finally, I think a concession by her that this is something she would do, and then nothing happened before she left office. And in fact, she just said, she was not prepared to bind her successor. So, what's the word? Bereft of proper ideas to proceed, actually. It's not rocket science.
But if you do the right thing, why would it be wrong to bind your success?
Commissioner, I think that's a question that should be put to the NPA, that every official in a senior position makes decisions that in effect binds those who come afterwards. And if those decisions are wrong, then steps will be taken to set them aside. But it is about the courage and having the boldness to actually admit you were wrong in what you did before and saying, we think this is the right direction to go in. And I'm afraid, listening to the saga around the country of what was going on, this seems to be a challenge.
Ms. Suk, if we can move to another topic. It appears that you led the charge on behalf of the Foundation and the families, as well as the former TRC commissioners, to call for an independent commission of inquiry into the measures that were taken that ultimately blocked the bulk of the TRC cases from going ahead. And Commissioners, the Kalata affidavit does provide an overview of these different calls and letters from page 184 of the Kalata affidavit, paragraph 483 onwards. Masuka, can you take us through the various communications that you spearheaded?
Yes, I think the first letter that we sent as commissioners was on the 5th of February 2019. And I think there were 2 points that we made in the letters. One was that we called upon the President to actually apologize to victims for both the political interference and for the delays, really, in dealing with their cases. And the second, of course, was we asked for the appointment of a commission of inquiry to investigate the suppression of the TRC cases. One should remember that by then we had had the Inkarimeng 2 application, and in that application we already had references by 2 senior members of the NPA, Vusi Pikoli and Anton Ackerman, referencing the political interference in their jobs and also the way in which they had been denied the resources and the tools needed for them to do their jobs. Then, of course, you had the case of Ahmed Timor, and when Jean Rodrigues applies to the High Court in Gauteng for the stay of his prosecution, you have the filing of further affidavits by Advocate Chris McAdam and Advocate Tari Pretorius. And again in there, it was quite shattering to read that since 2003, there had been a moratorium in place in terms of investigations of the TRC cases. This was set out in Chris McAdam's affidavit. And it made you, I think for all of the families, it was about, here we are dealing with an institution, talking to them constantly, but you're never really told that behind the scenes there's an active campaign to make sure that these cases never really get off the ground. And, you'd also had, I think, all of the issues that had been raised around the political interference set out in these affidavits, the notion of a secret amnesty task team, which I think you're going to have to go into greater detail when you receive the evidence of Vusi Pikoli and Anton Ackerman. And the fact that, hardly any investigations had taken place, and in fact, pretending to us that investigations were taking place. In the Timor matter, we all thought that they were doing their work. And then, in fact, we found that, nothing was actually happening in these cases. So, in a sense, I think it was our outrage at the way in which not just the state, but its institutions were dealing with these questions of the Apartheid era crimes that compelled us then to write this letter. One, I think we wanted an acknowledgement from the head of state that, in fact, people's rights had been violated. And to be frank, as Lucanio and Tembe both said, could anybody be sitting in government had it not been for the sacrifice of their family members? And so this was clearly, I think we were trying to get, the president to acknowledge, in fact, that wrong had been done to the victims of families, and that, in fact, the state and those who represented had compromised their rights. We also set out in that document why it was necessary to look at this question of political interference. And, I think at that point we were so anxious to grasp at straws that we even said to him in that letter that he could actually instruct Judge Zondo and the Zondo Commission to also look at the TRC cases as an aspect of the work that he was doing. And in fact, later on, Lukanya Karata files an application to the Zondo Commission for Judge Zondo to take up that matter. And so those were the factors at that particular point which in fact resulted in us stepping out of, I guess it was going to former commissioners and saying, I know this is not what you're doing now, but will you be willing to put your name to such a letter? And I think we were very fortunate that so many of them who were available were willing to sign up onto the letter, because they all were outraged by what was happening to the families of victims.
Who were these commissioners, Ms. Suka?
Firstly, Chairperson, the Archbishop agreed to put his signature there. Then Advocate Dumisa Insibeza, Miss Mary Burton, Miss Glenda Vilskut, Dr. Faisal Randera, Mr. Richard Lister, Reverend Bongani Finger, Advocate Denzel Potgieter, Dr. Wendy Orr. There were also committee members, Dr. Russell Ali and Professor Pitt Meiring. And then there were also a number of organizations, the Center for the Study of Violence and Reconciliation, the Pulamani Victim Support Group, the Institute for Justice and Reconciliation, the Foundation for Human Rights and the Ahmed Timur Thambi Trust, the Legal Resources Center, the South African History Archives, and then there were a number of individuals as well, the Imtiaz Kaji, the Imam Harun family, Mr. Mohammed Harun, Miss Fatima Harun Masood from the Imam Harun family, Mr. Lucanio Kalata, Miss Jill Berger, the sister of Neil Agate, Miss Shirley Gunn, Mr. Hugo van der Merwe, Miss Valdi van Rienen Leroux, Miss Maxine Rubin, Miss Judy Seidelman, Mr. Stanley Henkeman, Miss Sophia Bray, and Miss Piers Pigo. And these were all individuals who were also working at many of the institutions at the time.
So as I understand it, Ms. Suka, that was the letter dated 5th February 2019 on behalf of all those you mentioned. Commissioners, that's annexed as FA 68 to the Kalata affidavit. It can be seen in bundle 1 at page 746. But there were further efforts, further communications with the President on this issue. Could you take us through the other two letters that the former commissioners addressed to the President?
Chairperson, the second letter that we sent was on the 25th of March 2021. And I think the context around that letter is that we had been made aware, I think, that the Zondo Commission was not going to be able to look into this particular case. And so again, we wrote to the President. But this time around, we didn't ask for an apology. I think we realized we were not going to get one. But we again raised the question of the need to investigate the suppression of the TRC cases. And we referred to our letter, the earlier letter that we had sent. We also referred to letters that had been sent by a number of families on the 23rd of June 2019 and the 23rd of June 2020. And this was from the families of Chief Albert Lutuli, the family of Steve Biko, the Craddock Four, the Nakatula Simelani family, Ahmed Timol, the Neil Agate family, Imam Harun, the family of Matthews Mabalani. And I think, if I recall correctly, and I stand to be corrected, I think Philip Mabalani, the father of Matthews, had died in that period before getting a decision from the NPA. The family of Hussein Hafiji, Ashley Creel, Nicodemus Kwathe, Solomon Madifane, the Jacob Manakhatla family, Mapetla Mahapi, and Imkolisi Diki, and then Caiaphas Nyoka, Anton Franch, Oshin Jina, Harun Aziz, Colleen Williams, and Robert Waterwedge. And I think in their letters, these families expressed their pain and anguish at having been denied truth and justice, and they also called for a commission of inquiry. Sadly, of course, their letters, like our letters, were ignored. And so in that letter, we say that in the light of the president's failure to respond, the representatives of several families had approached the State Capture Commission with a request that it inquired into the NPA, the capture, of the state institutions meant to pursue justice in respect of the TRC cases. And we raised the fact that the Zondo Commission had indicated that it was unable to complete its investigations into this matter, and that it would close on the 30th of June, and that the remaining period of office that they had would be devoted to the preparation of their final report. And so because of that, because that avenue had closed, we in fact renewed our call for a standalone independent commission of inquiry to investigate the suppression of around 400 serious cases. And we pointed out that these involved murders and disappearances from South Africa's past. In our letter, of course, we pointed out that there was no longer a dispute, in fact, as far as we were concerned, around the political interference, and that had blocked several hundred cases in which amnesty had been denied or not sought. And we pointed, in fact, to the fact that senior officials representing the NPA had admitted under oath in 2019 that the NPA had succumbed to political interference in respect of the TRC cases. And the reference, of course, to that is in our letter. And I think counsel can probably give you, I think it's littered throughout here, the affidavits of the NPA officials. We also had Vusi Pikoli's affidavit and that of Anton Ackerman, which they had provided in the Nkadimane 2 matter. And we pointed out that, in fact, the full bench in the Rodriguez matter expressed its dismay and asked the question, how could such interference take place in a new constitutional order? And it, in fact, called on both the executive and the NPA to take up appropriate action to ensure that such breaches of the Constitution do not recur. At that point, of course, neither government nor the NPA had done anything. Of course, later, the NPA appointed, I think, my colleague, Advocate Dumisa Ntubeza, under very narrow terms of reference to look into these issues. And so we pointed out in the letter that while some evidence had become available, we were also concerned about the fact that you had the secret amnesty task team created by the Director General's Forum in early 2004 to explore not means of dealing with accountability, but actually when you begin to look at it, it's the means of guaranteeing further impunity for apartheid-era perpetrators, and that the departments involved were multiple: the Department of Justice and Correctional Services, National Intelligence. What is national intelligence doing in dealing with this kind of matter? The NPA, SAPS, and of course the Department of Defense. And from the available evidence, it was quite clear that at a very senior level, politicians and cabinet ministers, senior civil servants, police officers, and prosecutors were all involved in efforts to ensure that the TRC cases never saw the light of day. And we pointed out that we didn't think that it would be sufficient for individual departments to run internal inquiries. It had gone beyond that, and that is why there was the need for this kind of commission. And I mean, I'm not going to read the entire letter, but we actually point out the cumulative harm that victims, in fact, have suffered. And we pointed out to the president that while, I know there's a fatigue in South Africa around commissions, but what commissions of inquiry can be are investigative tools which the President may invoke for purposes of investigating matters of public concern. And I think we believe that this was a matter of public concern. And we said that the further objective is to also reveal the truth pertaining to the suppression of the cases, which would give it a deeper public person. And we, I mean, I think there was a question to Lucanio Kalata about what is public interest and what is national interest. I think in our letter we point out that the notion of public concern should be interpreted to promote the spirit, purport, and objects of the Bill of Rights, and to underscore the democratic values of human dignity, equality, and freedom, and that in respect of the suppression of the TRC cases, those democratic values have been obliterated. And we talked about how deeply offended families have been because their right to equality before the law has been grossly disrespected. The TRC cases have been treated differently from other serious criminal cases, and at that point in our letter we say, for the purposes of serving undisclosed political and ulterior ends, and such brazen arbitrariness should have no place in South Africa's constitutional order. We also quote, I think, from the late Justice Arthur Chaskelson in our letter. And he said, I think a few months after South Africa's democratic elections in 1994, we need to remember that the first incursion into rights is often the most damaging, and that once inroads are permitted, the will to resist subsequent incursions is lessened. And we, I think at that point, said that if we did not hear from him and receive an indication of his intention to establish a commission of inquiry, we would refer this matter to our attorneys to look at how we could vindicate the constitutional rights of families of apartheid era crimes and bring an appropriate application to court. And I think that's a question, what Judge Chaskelson said, when you begin to look at the incursion of rights following the amnesty process. And this is when the criminal justice system must play its role. So from the outset, you have a political incursion into rights. And when you look at where we are today, look at the number of cases, it's quite shocking that out of 400, hardly any of them have been dealt with. So that was the tenor of the letter of the 25th of March 2021.
And Commissioners, that letter is annexed to the Kalata affidavit at FA 74, and it can be seen in bundle 1 at page 783. And Ms. Suk, I assume that you're now going to move to the next letter?
Yes.
Please go ahead.
It's not, you know, in a way it's not really a letter. It's a public statement from the former commissioners, and that's dated the 9th of November 2021. And it takes place against the backdrop of, I think, the then Minister of Justice, Minister Ronald Lomola, was invited to address the inaugural launch of the Fort Kalata Foundation's memorial lecture. And in his speech on the 5th of November 2021, the minister indicates that he had already appointed an inquiry to investigate the suppression of the cases. And he indicated in his address, his public address, that the investigation would be presided over by a judge. The minister didn't, of course, talk about what would be the terms of reference, and neither did he indicate who the identity of the judge. He also gave no indication of how the judge was appointed and under what legal authority. And when he was asked the question about whether this inquiry would be opened or closed, the minister said he would have to discuss this with the judge in question. And he declined in the question time to give his own view on the matter, stating that it would amount to a policy statement. So his response to our previous letters is his own thing. Judge, inquiry, we don't know the terms of reference, don't know if it's going to be closed or open, but no consultation whatever. And we point out in our statement that since the President is not involved in the appointment and no mention was made of the Commissions Act, it seemed to us that the envisaged inquiry would be an internal one behind closed doors. And what we had intended to be an open and transparent process was not actually going to happen. And, you know, the fact that he didn't hesitate, he hesitated on the question of open or closed, I think for us was quite telling. And normally, I mean, judges are not just appointed. I mean, you would have to have some kind of inquiry by the executive, and it had to be asked why the minister had taken this extraordinary step forward. And I think his decision obviously must have been a direct response to the fact that we'd sent these previous letters, which had been ignored, and we could only deduce then that aside from the acknowledgement, you know, he'd announced this inquiry because he didn't want to hold a classic commission of inquiry, and that it appeared to us that the state wanted to avoid an open and public inquiry into the suppression of the TRC cases. And honestly, we think that it must have been for purposes of damage control. We also, in our public statement, you know, provided links to both our letters and the letters that had been sent, you know, by the families as well. And I think we also had a kind of chronology of the political interference. So we then, you know, also noted that it would be important to know whether the Commissions Act was going to be applied, because we pointed out that commissions do have the power of public hearings, the power to subpoena witnesses, the fact that they could call witnesses, cross-examine, and that you would have the participation of victims and other stakeholders. And while it was possible that attempts would be made to deflect criticism by allowing victims to make submissions and requiring the judge to issue a report, nevertheless it would remain a closed inquiry. And so effectively, we and the families would be shut out of the inquiry. And I mean, we pointed out that an inference would almost certainly be drawn that the inquiry had been so designed to protect powerful elements in society and shield them from scrutiny and embarrassment. We also pointed out that you can't have the executive investigating themselves, and that's effectively what this kind of inquiry would be. And so, you know, we said the suppression of the TRC cases involved multiple entities and individuals across the public sector, including the Department of Justice, National Intelligence, the MPA, SAPS, and the Department of Defense. And we said that the available evidence suggests that politicians, cabinet ministers, senior civil servants, police officers, and prosecutors were all involved in efforts to ensure that the TRC cases never saw the light of day. And so an internal inquiry cannot hope to get to the bottom of a problem of this magnitude and sensitivity, and that an internal investigation will not be able to deliver the full history of interference as it unfolded over time, over multiple departments, and within and outside of government. And to be frank, it was quite absurd. And we also, I mean, I'm not going to go through all of it, but we said that the track record of SAPS and the NPA speak for itself. And in these circumstances, it's really disturbing that the minister had seen fit to reject a public commission of inquiry to favor an internal investigation. And we said that members of the executive will be expected to investigate their own colleagues, such an inquiry will have little or no credibility and in the eyes of the public, and the gloss of an oversight role of a judge will not change that. I think we also pointed out, and I think this is a question for judges, you cannot lend your name to inquiries of this kind. It also brings the judiciary into disrepute, and so the fact that a judicial officer is required to lend judicial legitimacy to investigation conducted by the executive, I think is problematic and harmful to the institution, and is a breach of the separation of powers principle, rendering such an appointment unconstitutional. And then, of course, we go back to our plea, the need for a proper commission of inquiry. We point out that there's no longer any dispute that political interference blocks several hundred serious criminal cases, and that, again, we reiterate all of the senior officials in the NPA who have made affidavits and provided evidence along the lines of that, give them all the references. And we point out that while we know a lot, we certainly need to trace this line properly, and we need to understand what was behind it. Again, we point out that the subject matter is of great public concern, and that perhaps more than any other class of cases, the suppression of the TRC cases has been almost total in its impact, and virtually all the cases were blocked, and most of the cases cannot be resuscitated, as perpetrators, witnesses, and family members have died over the past number of years, and the impact visited on the families is incalculable. The harm demands, we point out that the harm done to them demands an expeditious, thorough, and credible inquiry into the machinations that resulted in such a massive denial of justice. And I mean, it is, we point out in the press statement that it's a critical matter of restoring public confidence in the government as a whole and the institutions implicated in the suppression of the TRC cases. The victims already having lost faith in the government, especially SAPS and the NPA, and an investigation held behind closed doors is likely to destroy all confidence and trust in the state. We also, talked about the anxiety that this would lead to for families and communities, and that it would again deeply violate their rights to human dignity, equality, and the rule of law, and that the refusal to hold an open and public commission of inquiry would only exacerbate the violation of their rights. In the letter, we were quite realistic that it could be argued that the country is suffering commission fatigue and cannot afford yet another commission of inquiry, particularly after the State Capture Commission, and we put out the cost at $1 billion. But we said that such an argument would be deeply insulting to the families who endured apartheid era crimes. Their loved ones laid down their lives for our democracy and its enshrined freedoms. And we said not only has the post-apartheid state turned its back on them and suppressed their cases, but in raising such an argument, it would say that they are not worthy of, having such a commission of inquiry. So that was the press statement that we sent to, that we also circulated and sent again to the President and the Ministry of Justice.
Thank you, Ms. Suka. So, Commissioners, that press statement is annexed to the Kalata affidavit as FA 79, and it's in Bundle 1 at page 806. So Ms. Suka, you seem to be saying through these different communications that the state at that time was willing to hold, in your words, an internal inquiry which you feared would be stage managed, but that you weren't getting a positive response in relation to a independent or credible standalone inquiry that couldn't be interfered with by outsiders. And what did that say to you about the approach of the government?
I think we were a nuisance, an irritant, because we were sending these letters to the President and the Ministry of Justice, and we were making them quite public. And then, of course, we produced this media statement, which I think, well, the media statement comes afterwards, but I think that the letters obviously were irritating for the government and a nuisance. And so one way they thought they could get rid of us was, let's do this, let's set up an inquiry, we'll say it will be chaired by a judge, but we won't allow it to be a fully fledged commission of inquiry. And that way these people will go away. Only, I think, the families of victims are fairly tenacious and persistent, and they were not going to allow that to happen. And so immediately, I think we heard, what the minister had said at the launch of the inaugural lecture. That is when we released the media statement.
And in your earlier evidence, I recall you saying that in relation to some of the cases, the authorities had to be dragged kicking and screaming. Given that the families in this matter had to launch a substantial and massive application to court before President Ramaphosa was agreeable to appointing a commission of inquiry, would that same description be apt in relation to his conduct?
Absolutely. It's what do we say? You have a tick box approach. So you want them to go away. So you say, well, I'm going to do something, but what I'm going to do will fall far short of what you really want, but it will satisfy our need to show we actually did something. So I think it was very much along those lines, and it was problematic.
You mentioned in your description that the letters had referred to certain developments, and in particular the fact that there have been affidavits filed by the NPA in the Rodriguez case. You mentioned that Rodriguez had been charged with the murder of Ahmed Timol, and that he sought a permanent stay of prosecution because of the long delay. I want to put to you excerpts from the affidavit of Advocate T.P. Pretorius SC. He filed a supplementary affidavit in this case after the families had put up all the evidence that you spoke about in relation to what was in the statements of advocates Bacoli and Ackerman, where they referred to the on pages 139 to 140 of the Kalata founding affidavit from paragraph 360 onwards. The affidavit of Advocate Pretorius is annexed to the Kalata affidavit as FA 50 at page 624. And I'm reminded that the full papers in that matter, the Rodriguez matter, has been supplied in the contextual document. I'll paraphrase just to save time. He says that the NPA doesn't deny that the executive branch took steps which can be described as political steps to manage the conduct of criminal investigations in these cases, such as that of Mr. Timol. But he stressed to say that this was not the doing of the NPA. They did not act out of any malice. It was simply a result of the pressure or interference that they were subjected to, and that none of these incidents that were set out by Bacoli and Ackerman were created or initiated by the NPA. And he then called on the court to send a clear message to political office bearers to stop interfering with prosecutorial decisions. Now, what is your response to what the NPA said in that matter, which is essentially, yes, it happened, but it wasn't our doing. We did not act out of malice. This was the work of somebody else. What's your response to that?
You know, he paints himself and prosecutors as if they are victims. The real victims are the victims of apartheid era crimes and their families. And, you know, the only two who were courageous enough, I think, at the outset to take action were Vusi Pikoli and Anton Ackerman. The rest of them just acquiesced and went along. And I think that really raises a question for us. Is that the kind of institution you want? Is that the kind of independence that should be displayed by the National Prosecutorial Authority? They dragged like sheep along without objecting, without raising their voices. I didn't see anything in his affidavit where he said that he can't do his work. Unlike Vusi Pikoli's memorandum to the Minister of Justice, in which he sets out how untenable it has become for him to do his work, you don't see a similar set of circumstances here. And so I don't think that's good enough. And, you know, it reminds you of many of the soldiers who are involved in committing grave violations when they argue obedience to orders. Is this what we're having? A public institution where officials entrusted by the state to act independently are dragged along by politicians? I don't think that's what our expectations are of the NPA. And I think that really raises, I think, profound questions about how we begin to shore up this question of independence and how we build fearless prosecutors who are not afraid to take on the state. And, you know, it reminds you of prosecutors in many other countries. If you look at the Pinochet case, for instance, you know, originally Chile was not so keen to take on the case, and it required a prosecutor from Spain to bring the case under universal jurisdiction in the UK courts, and that prompted, I think, the Chileans to actually deal with their matters. So similarly here, I mean, you have Vusi writing to the minister saying that the way in which this process is unfolding, I can't do my job. And nevertheless, he continues to do his job, and he's fired for that. I mean, he's suspended because of the TRC cases. And when you look at the initial charges of the Diale Commission, one of them was the TRC cases, but that was later dropped. So if he had the courage to stand up, why did the rest of them not follow? So I don't find his arguments acceptable. I think it's quite shameful, actually. The real victims in our country are the families who have been left behind, and that's something that we need to acknowledge. Also, you know, it goes to, I think that there was a briefing when the former President Thabo Mbeki released a statement saying that they didn't do their job and that they need to answer for what they did. But I think he needs to answer also for the person in command responsibility, having superior responsibility. What did he do after so many years around knowing that nothing happened on these cases? So there's an obligation on a whole range of state actors, because the head of the NPA, successive acting heads, and there were so many of them, but also the president of the country, the Minister of Justice, these were people in command or superior responsibility. When they knew what was happening, what action did they take to remedy it? And the answer is nothing.
You put up the interesting analogy of soldiers who commit atrocities, saying they have to take orders. what's interesting is that in the affidavit of Advocate Pretorius, and this is summarized at paragraph 362 of the Kalata affidavit on page 141, Pretorius SC says that the NPA had little choice in the matter because the NPA prosecutes on behalf of the state. What's your reaction to that?
The NPA prosecutes on behalf of us, the people. It's their constitutional obligation to uphold the Bill of Rights and the Constitution, and that interest is ours. And so even a head of state should be capable of being prosecuted by the NPA.
So in your view, when pressure was applied on the prosecutors in respect of the TRC cases, what should they have done at that time?
Lots of actions open to them. They could have resigned en masse. They could have jointly got together and made a public statement and demanded, in fact, that Parliament do something about it. So there are many things that they could have done. Instead, acquiescence for, 30 years? Crazy.
Could they even have invoked the Constitution and approached a court in this matter?
That would have been the best course of action.
Yes, the statement to prosecute on behalf of the state, actually in other countries, it could be the people of South Africa versus so-and-so. Not so much the state, the people.
The people, yeah.
Don't you agree?
Yes, I do.
Okay.
I do.
Ms. Suka, before we conclude, I understand that you would like to make a concluding statement.
Thank you, Chairperson, with your indulgence. I want to say, Chair and Commissioners, that I'm profoundly grateful that this commission was established and that its proceedings actually got off the ground, despite, I think, numerous attempts to derail it. Its very existence affirms a principle that lies at the heart of our constitutional democracy, that the state must answer when it has failed the most fundamental duty to protect the rights of its citizens and to ensure justice for grave crimes. The families of those who were tortured, killed, and forcibly disappeared under apartheid have walked a long, lonely road since the Truth and Reconciliation completed its work. They came forward in good faith. They gave their testimony publicly, often at great personal cost. But they did so in reliance on a solemn promise, a constitutional compact, that the truth would be followed by accountability and that their suffering would not be rendered invisible through official inaction. This compact created binding constitutional and legal obligations on the democratic state. Victims relinquished their ordinary entitlement to insist upon immediate prosecution in reliance on a lawful process that preserved accountability. So when the state failed to investigate and prosecute cases where amnesty was not granted, it breached the constitutional bargain at the heart of South Africa's democratic transition, and it violated the legitimate expectations it had created. It was not supposed to be like this. The democratic state that, that their loved ones helped to bring into being, often at the cost of their own lives, was meant to stand as the guarantor of their rights, not as the custodian of their abandonment. The conditional amnesty regime established under the Promotion of National Unity and Reconciliation Act was expressly designated as a mechanism of accountability within a transitional constitutional framework. It was an exceptional measure, carefully circumscribed by law and embedded within a broader legal architecture that preserved and did not displace the ordinary operation of criminal justice. Amnesty, as we know, is not automatic or collective. It could only be granted where perpetrators made full disclosure and satisfied strict legal requirements. Where they did not apply, or where amnesty was refused, criminal liability remained intact. And the legal duty of the state to investigate and prosecute was neither extinguished nor diminished. This duty arises directly from the Constitution, which requires that the state uphold the rule of law and respects, protects, promotes, and fulfills the rights to equality, dignity, and equal protection of the law. I would argue that when we talk about equality, the perps seem to have enjoyed more equality. So failure to investigate and prosecute is therefore itself a violation of the Constitution. This framework was crafted carefully by those who negotiated our transition. The late Minister of Justice, Diale made clear that conditional amnesty was never intended to extinguish accountability. It formed part of the justice system and was not an escape from it. Those who came forward and told the truth would be considered for amnesty, but those who did not would remain subject to investigation and prosecution under the ordinary criminal law. The logical consequence of this legal structure was clear and unavoidable. Individuals who failed to apply or whose applications were refused remained subject to criminal investigation and prosecution. And when the state failed to act on these cases, it did not merely delay justice, it violated constitutional obligations. It denied victims their right to an effective remedy, it denied them their right to dignity, and it denied them their right to equal protection of the law. But it also violated South Africa's binding obligations under international law, including the duty to investigate and prosecute torture, extrajudicial killings, and enforced disappearances. And these are not discretionary, they are mandatory legal obligations. The consequences for victims and their families have been profound. It has meant 3 decades of uncertainty, unresolved grief, and the corrosive knowledge that those responsible for the worst crimes walk freely among them. Their loved ones gave their lives in struggle to bring into being a democratic constitutional state founded on the rule of law. Yet that very state has failed to vindicate their rights. For perpetrators, the message has been equally clear. Delay has become de facto impunity. Silence has carried no legal consequence. The passage of time has been allowed to shield criminal responsibility. And this failure has not remained confined to the past. It has weakened the authority of the law in the present, and it has contributed to a culture in which those who abuse power may reasonably doubt whether accountability will ever follow. And the human cost of this failure is immeasurable. The failure has also inverted the moral and constitutional order. Instead of vindicating the rights of victims, the passage of time has operated to the advantage of perpetrators. Instead of reinforcing accountability, state inaction has entrenched impunity and undermined confidence in the rule of law. For nearly 3 decades, victims and their families have waited for that duty to be fulfilled. They placed their trust in the institutions of the democratic state. Instead, they've encountered delay, obstruction, and political interference that has subverted the cause of justice. As Lucanio Pilato testified before this commission, the failure of the democratic state has compounded the original injustice. He spoke not only as the son of Fort Kalata, but as part of a generation that placed its faith in the Constitution. He told this commission, and I quote, "We believe that the democratic state would do what the apartheid state never did, respect the law and prosecute those responsible. Instead, we have been betrayed by the very state our parents died to create." His testimony captures the profound constitutional injury that has occurred. The failure to prosecute has not only denied justice for past crimes, but it has eroded the constitutional promise for which their parents sacrificed their lives and has perpetuated the violation of victims' rights into the present. I recall last year how, after a deeply frustrating court hearing, Tembi Similani approached the perpetrators in the recess, and she asked them simply, please tell me and my mother where my sister's body is buried. She didn't ask for vengeance, but for truth, so that her family could lay their child to rest with dignity. They callously brushed her aside, and that moment reflected not only personal cruelty, but the structural cruelty of a system that has allowed silence to prevail where the law required accountability. The right to truth, to justice, and the right to dignity are not abstract ideals. They are binding legal rights. And when the state fails to investigate and prosecute crimes, it itself becomes complicit in the continuing violation of those rights. And each day that accountability is deferred constitutes a continuing violation. The Constitution requires not passive acknowledgement, but active enforcement of accountability. And so the Commission, unfortunately for you, you carry a profound constitutional responsibility, and you must affirm that the rule of law applies equally to all, and that the passage of time doesn't extinguish accountability. And you have to affirm that the rights of victims remain enforceable, binding, and deserving of protection. Accountability isn't only about addressing the past. It's about restoring the integrity of our Constitution, about affirming the dignity of victims, and it's about ensuring that the promise made at the birth of our democracy, that justice would follow truth, remains real, enforceable, and alive. And it can send an unequivocal message that in South Africa, no perpetrator, no matter how powerful, and no matter how much time has passed, is beyond the reach of the law. So it's an awesome responsibility, for which I thank you.
Thank you, Ms. Suka. No further questions, Commissioners?
Thank you, Mr. Van. Ms. Ranto, any clarification, questions?
Thank you, Commissioners. There is no clarification sought from the SAPS. Thank you, Commissioners.
Ms. Moroka?
Good morning, good afternoon, Commissioners. None sought from us, but we will approach the Commission with an application to cross-examine. Thank you.
To?
Cross-examine.
To cross-examine. For the DSO, for the DOJ? Yes, ma'am?
No, she isn't. She's my junior.
Oh, she's a junior. Mr. Siminya?
With your indulgence, can we commence our part just after lunch? I see it's almost 5 minutes to.
Yes. Can we agree that we will then reconvene at 10 to 2? We are adjourned until 10 to 2.
Has the Commission, please?
Mr. Siminya?
Chair, we thank you for the indulgence, and I must indicate that we do not intend to be long, and this section will be handled by my learned colleague, Mr. Soni.
Yes, Mr. Soni?
Thank you, Chairperson. Good afternoon to you, Ms. Suka.
Good afternoon.
Maybe you could change chairs or switch. Yeah. Oh, okay. That's an easier way, yes.
Ms. Suka, I want to begin by noting the following. First, it's clear from your background that you have been involved in securing solace and justice for the victims of the atrocities of apartheid for a period long before the TRC process was conceived. And for this, Ms. Suka, we all applaud you. Thereafter, Ms. Suka, you were involved intimately in doing the same during the TRC process itself. For this, Ms. Suka, we all thank you. Now, this morning, you instructively reminded us that the TRC would not grant amnesty until the truth was disclosed and other criteria set out in the TRC Act had been met. And whatever else, this would provide, the truth itself would provide some solace for the victims of those atrocities, and those were cruel atrocities, and their families. It's perhaps also worth recording, Ms. Suka, why that painful decision to grant amnesty to the perpetrators of the most heinous of crimes was taken. And that was pointed out by the Constitutional Court in the Zapo matter, where the court pointed out that such a process would perhaps be more successful in securing truth for the victims than a prosecution process, especially in the absence of evidence, which in all probability was destroyed during the dark apartheid days, and because these crimes took place where there was a system of no accountability. I'm just placing that on record because it is necessary to know how we actually got here. Would you agree with all of that, Ms.?
I think that we could have quite a debate around some of the assertions at the time, and I can tell you that as a member of civil society who was part of the discussions around the question of an amnesty, and also, really looked at the Zapo case properly. I think the Zapo, when we look at it, is a political judgment, and it's a political judgment in the context of the time of the transition. And I think that many of the assertions that were made by Justice Mohammed writing for the majority, one could have an issue with. And I would argue that that probably needs almost a separate debate, because I would beg to differ around the assertion that in almost all cases there was no evidence. So I think that's one part of the Zapo judgment. I also think that, remember in the Act they used the word full disclosure, because the notion of what is the truth depends on which perspective you look at it from. And I think it was Judge Albie Sachs, when he was dealing with the question of his own testimony before the Human Rights Violations Committee, he came up with this, notion that is being used in many other transitional contexts today, that you have many different kinds of truth. There's the dialogical truth, which emerges from a process like the Truth Commission, but that, we've also had the situation where people thought that the forensic truth that you get from court cases, that was enough. And now we know today that many people lied to the courts during the apartheid period as well. So I think the Act deliberately uses the word full disclosure and not the truth, although victims and many people talk about it as the truth. But I think that all of us accept, and I think that was a bitter acceptance, that it was necessary to go down this road in order to ensure that we would have a peaceful transition. And the only reason that we accepted it was because we were assured that the rule of law would follow its course once the amnesty process was over. And so the amnesty is what we call an exception in time, only permitted in certain circumstances. And today, when you look at the normative framework around the world, amnesties are prohibited for serious international crimes, and it would include all of the crimes that are listed as gross human rights violations in the TRC legislation. So I think it was an incredibly generous moment. And if people chose not to make the best use of it, if they chose not to make full disclosure, then I think that is when the law falls into place. And that is why the imperative to investigate and prosecute is such an inviolable part of the deal. So yeah, sour, bitter pill to swallow, but accepted as necessary at the time. But we, and in the negotiations, when we try to look at closing all of the loopholes, I mean, you can't foresee everything. And I think, these are some of the bitter lessons that we've learned over the years.
I think the Zapo judgment does deal with that and accepts that at the end of the day, that was a choice that was made by the leaders of the different factions in South Africa at that time.
That's why I call it a political judgment for the time.
Yes, now I understand. But notwithstanding what was envisaged in the Zapo case and the difficulties that were presented there, in your evidence this morning, you pointed out something that, and that's why I mentioned the difficulties in the Zapo case. You pointed out that you and Mr. Nsebeza took lists to Mr. Bulelani Nguga and now Judge Saldanha of what had happened, what possible investigations there were. So all the difficulties that had been set out in the Zapo case, certainly in respect of those lists, well, not necessarily all the difficulties, but many of those difficulties would have vanished because you had something to work from in pursuing a meaningful investigation.
Yeah, I concede that in many ways there are elements of the amnesty process which did create the basis for proper investigations in the future. But I would also venture to say that when you look at the work that was done by the Diale unit, and you look at the work that was later done by the Goldstone Commission, I would say that there are a vast number of cases which, if the NPA had been left to just exercise the authority without the Truth Commission, that could have also proceeded without the amnesty process. But amnesty process was useful in giving many families a leg to stand on.
Yes. Well, in addition to the progress made by, for example, the Goldstone Commission and the Diale unit, what we do have is the amnesty process created by the TRC, which also brought further information. Admittedly, not as much as one would have liked, but it did bring that further information. As I understand your evidence, and correct me if I'm wrong, part of the concern, and perhaps just putting it mildly, that you raise is, notwithstanding all of this information that was existing and that the TRC process had brought, we are still here today with a handful of completed investigations, fewer prosecutions, and a couple of inquests which don't require much investigation. Would I be correct in saying that is part of the concern you express?
Yeah, and I think the reason we are here at this commission, I think to ask the question, why? You know, when you look at the fact that the amnesty process did bring to bear a whole load of information, and if you couple that with, you know, what the other two bodies did, and remember there were other trials that took place in the country before, as the commission was setting up, and before the commission, for instance, in KwaZulu-Natal as well. I do think that with that kind of archive of information, it does beg the question, why was it so hard then to advance prosecutions? And maybe just an example of one, I mean, when you look at the Craddock 4 case and you look at Neville Zietsman, he may not have named the security branch officers, but he did attribute responsibility. And so from that point on, it was not rocket science to do more work. I think that emerges in the Amnesty Committee. And so one has to ask the question, when the amnesty judgment came in, why was that matter not seized upon and indictments issued? And we could go to a range of you know, other cases, including that of Simelane, including that of Timol. So I think with a little bit of diligence and perhaps more courage, you could have had a very different response.
What, as I understand your evidence, based on the different cases that you refer to and based on generally what happened, you say that this lack of success is due to the suppression of the TRC cases. That's how I understand your evidence, Ms. Suka. Would that be a correct description of the general tenor of your evidence?
Yeah, but I mean, when I say suppression, I mean that suppression includes the deliberate political interference that went with it. And I think that there you have the evidence of members of the National Prosecutorial Authority themselves making those admissions in affidavits before two court processes. And I think that when one looks at that, then I think that leads one to the inference that there was suppression and political interference. But there is a question, though, and maybe incorrect of me to say that, but like there could have been a lot more work done, even if there was political suppression. And the question of what one did was also dependent on how committed you were to dealing with your own responsibilities, because it is a question of responsibility.
And I think, Ms. Suka, if I can be so bold as to suggest that it took the efforts or the lack of effort of a whole range of players for us to come to this point where victims are still, as Mr. Kalata put it, there with holes in their souls. And I mean, that was his graphic description of how he feels, not knowing what happened, for one, and not being able to say that when the perpetrators were alive and they were not prosecuted, he was denied justice. I'm just giving one example.
Yeah.
But the point you make is that it was not a single group of people. It took a range of people from different parts of government to arrive at this sad state of affairs we find ourselves in now.
I think it's a question of the institution, government and its institutions. At one level, there are politicians, there are senior civil servants, but when you look at the three, maybe two key institutions that are meant to uphold criminal accountability, the National Prosecutorial Authority, and then, of course, supported by the South African police in the form of whatever investigative units they have. These are institutions, but they also, and I mean, that's where I raised the question of, if you align that to the question of accountability at a command level, the head of state, the head of a particular institution, these bear superior responsibility. And because, I mean, they knew from the outset, I mean, that nothing was happening there. What action did they take to change the situation?
And if I could add to that, Ms. Suka, Parliament too must take its blame. One looks at the appearance of different persons like the NDPP, the prosecuting authorities, the ministers, and so on. And one hears very lofty principles being set out. And then 2 years later, exactly the same thing is said in those hallowed chambers of Parliament, and nothing is done.
I mean, in a way, it goes to the question of the institutions which are meant to preserve democracy. On the one hand, you have the executive, and then, of course, you have Parliament, and you have all of these institutions. And to be honest, in this particular instance, had it not been for civil society, there would be no accountability. And so Parliament, too, at some point, has to accept its responsibility. And it's quite interesting, because when you go to the period preceding the setting up of the Truth Commission, the two houses, you know, the NCOP and Parliament, they sat together in a joint sitting. And when you look at the kind of engagement that took place on these important questions, you get a very different picture from, you know, what you've seen. Although I think that in recent times, you have seen the Portfolio Committee try to engage with the issues, and since they've been a lot more assiduous about keeping their, you know, the accountability going, it has been different. But I mean, it hasn't changed that, you know, the situation for the victims.
If I may just point out, that is, in a sense, part of what the Zondo Commission found, that had there been the oversight, the rigorous oversight role that Parliament was required to play, there wouldn't have been state capture. Now, in a sense, this too has been called a form of capture, because, as I understand it, when the Zondo Commission was approached, part of the approach was based on the fact that the prosecuting authorities and perhaps the police had been captured in a similar way to other government bodies, under government institutions in the grand play of state capture.
Yeah, I mean, I think that it's a very tricky question, because I think up until the GNU, I think when you have a very strong government with one political party in ascendancy, unfortunately, that does mean that both the institutions and Parliament too that particular perspective will hold. And so when it comes to checks and balances, it's very difficult. And I think you saw that in Zondo, and you probably seeing it here as well.
And I just want to suggest to you, Masuka, that to see this commission purely as the failure or the lack of effort on the part of the police and the NDPP would be to misconstrue the perilous state, if I can put it that way, and perhaps it's putting it too strongly, in which our entire democracy is.
And it is why I think some of us have said that when you look at the commissions that have been set up in the recent period, I think the Zondo Commission was about state capture. The Madlanga Commission is about the security forces, police particularly. But when you look at this commission is about the institutional heartbeat of our country. And that is why it's so important. It has to go beyond the notion of two institutions, but to look at the edifice of government and why this was possible.
And would I be correct, partly that's because of the centrality of the principle of the rule of law,
yeah,
and the supremacy of the Constitution.
Yeah. I mean, if you know, when you look at the debates that took place in Parliament, I mean, this is one issue. How do we ensure that as a new fledgling state, South Africa doesn't flout the rule of law? And so that is why all of these safety guards were built into the process. And when you look at, you know, Dala Oma's speech at the Syracuse conference, he was basically arguing with his peers around the world around why South Africa shouldn't be seen as an outlier state. And the only basis on which he could do that was because it was premised on the notion of a form of accountability, and within the context of a transition in which the rule of law would still remain uppermost, and that this was within the sanction of the Constitution, because I think that was so critical. And I mean, it's a very clever, when you look at the negotiation of the 34 constitutional principles, I think there's a recognition that the liberation movements and the apartheid government don't have the legitimacy to complete the process. And so that's why this is left then to the Constitutional Assembly to begin the drafting of the law. And so one of the first acts that they begin to get onto is the TRC legislation, with the notion that all of the accountability measures that are put into it, consultations, widespread hearings, before the finalization of the law.
And it perhaps won't be amiss to point out in our present history that unless our democracy is nurtured, it will face the same challenges that many Western democracies are facing at the moment, because you have the notion of populists in power, persons who ought to safeguard society against such abuses, not having the courage to do what they are required to do as public representatives.
Yes, I think that in that sense, South Africa is incredibly different. And, you know, I want to say that when you look at South Africa's position on the world stage, particularly when you know, relate that to the conflict in Gaza, the South Africans were standing alone initially, but because of their courageous stance, suddenly you had many other governments in the West also beginning to indicate that they supported that stance. And that is why I believe there's an enormous amount of hope in our society. The fact that our judicial system works, the fact that almost every single political party, when they feel aggrieved, they take their disputes to the court. And in a sense, having that and having a civil society that is active and courageous, I think these are important steps in a sense, nurturing what we have. And we have a constitution. You see in the United States, for instance, the way in which particular leadership tried to subvert the constitution, but you also, and I think you're seeing in the last 6 months, how many organizations are beginning to fight back. And I think these are important steps in asserting the notion that in the end, the people know what they want. And I think South Africa is very similar in that regard. You just have to look at the victims who've come to this commission, and you see their understanding of what the rule of law means for them.
And of course, with all the challenges that victims and organizations like the FHR faced from 2003, and begging for a public airing of what ails the system, we now have a commission of this nature that has been established. I mean, whatever else, and of course, whether it succeed or not is another point, but what we do have is we are here today so that these concerns of the forgotten victims of apartheid are expressed in public.
And that is why I think in my closing address, I think I said that it's such an important assertion of constitutional values to have this commission. I would only say one thing, and that is that we have some very powerful elements who are also people with an interest in this commission. But I was struck by the fact that, once again, they do not take the time out to listen to the plight of families and victims. And I hope, even if they were not sitting here, that they are watching the live stream so that they understand the pain and suffering of families. I think that that is what equality actually means. And so we've invested a great deal of hope in this commission because we think it's an assertion of the values of our society.
Ms. Suka, I had been hopeful that we would be able to say to you today that in response to your affidavit, and not only your affidavit, but as your evidence unfolded today, which emerged in many of the documents annexed to the papers, that we would be able to say to you that the government's response or the state's response to you is as follows. That is, Ms. Suka, I want to place on record, not due to lack of effort on our part. We've circulated these affidavits to all institutions who, as you have rightly pointed out, bear accountability for where we are today. They have unfortunately not responded. I'm just going to point out, perhaps to you and again to the world at large, that at the end of the day, our Constitution, in allowing for the President to establish a commission of this nature, and the Commissions Act, which gives power to the chairperson of the Commission and the Commission itself, that those coercive powers, it may be necessary to exercise them so that, as you put it, the silence, the resounding silence that greets evidence like yours, Mr. Kalata's and Ms. Simelani's, is not allowed to prevail in the face of the accountability of all who are responsible for the delays and interference in the prosecution or the necessary prosecution of perpetrators, or the search for the truth as to what happened to our many heroes, Chief Lutuli, Steve Biko, Fort Kalata, and many, many others. Amit Timor. But all of them, they deserve, their stories deserve to be told to the world, so that the world, but especially us as South Africans, know what really happened, and that the perpetrators will not be able to escape the sanction of history at some stage.
Thank you.
Thank you, Mr. Vani. Now, before you proceed, Ms. Gabriel has a question for Ms. Suka.
Suka, thank you for your evidence. You've taken us through chapter and verse of certainly the period before 2019, where you've pointed to what you've described as political interference. What's exercising my mind, and is a deep question, which I hope you came to some understanding about in your head, is why? Did you come to any understanding in your own head?
I think it's the million-dollar question, why? And maybe, it's pure speculation on my part. You know, at the time when the negotiations took place, I think we made the assumption that everybody believed that there should be Nuremberg-style trials, right? And when they didn't get that, then of course some people opted for the conditional amnesty. But I honestly believe, and you know, when you look at many individuals, and you look at the fact that they were impatient, even with the body like the Truth Commission, I think it's because there's this belief that we were fighting a war. And in a war, you have collateral damage, and civilians are collateral damage. And so now it's all over. We're in a new country. We should all move forward. So I think that's one angle, that there are people who don't believe that there should have been this kind of accountability framework. I think that you also have what is set out in the papers, in the sort of books of Michael Schmidt and the sort of interviews that Ali Bubenza conducted, and something that we always had a debate about with the de Klerk Foundation, that there was another deal. And that sort of deal would fall into that category of we were all fighting a war, and so why are we going down this route? And maybe that's, that element. But I also think that often when you spoke to ministers and senior officials, you were told that, well, if we go for them, then they're going to go for us. And I mean, the real issue should be, like, if you committed these kinds of serious violations, then there was an option open to apply for amnesty. And if you didn't get it, then obviously you would have to face the might of the law. So I can only speculate, as to what that reason is, and I hope that somebody's going to illuminate this sort of question, which I think a lot of us have pondered for many, many years.
And then after 2019, where you say it's less clear, you describe what you call a culture of endemic impunity. Help me understand that a bit more. What do you have in mind?
I think that that South Africa fell into a point where, because of the way in which these institutions had been denuded, that even where political will may have existed to do something, you see the way in which the capacity, the question of the quality of being able to do stuff, I think that has just promoted impunity, because it's very difficult in that environment to pursue accountability. So I think that's the culture that I'm talking about.
Thank you.
Mr. Vani?
Thank you, Chairperson. We don't have any follow-up in relation to this witness, but in discussion with the evidence leaders this morning, we felt it appropriate to place certain aspects of the evidence of Advocate Demise Nsebeza SC, who, as we've indicated previously, is not able to testify at this stage. But given the logical flow of the evidence and what he would have said, we think it's appropriate to place certain aspects of his affidavits on the record. And if the Commission agrees and gives us leave, we'd like to do so now.
Yes, you make sense.
If I may, Madam Commissioner, can I understand what is being sought to do by Mr. Vani?
Mr. Vani?
So, Advocate Demise Nsebeza SC was also a member of the Truth Commission and the head of the investigation team. So normally speaking, his evidence would have gone straight after the evidence of Ms. Suka. So, for example, he also was involved in the handover of cases to the Truth Commission. And his related evidence, we think, should be placed on the record now so that it is in the minds of the Commission and those involved in the Commission. There's a possibility that if Advocate Nsebeza, if his health improves, that we could potentially call him to testify before this Commission closes. But there is a possibility that he won't be able to testify. And so we felt the need to put his evidence on the record and to highlight aspects that we think this Commission should be seized with.
Understand, Chair, if I may. Is Mr. Vani proposing that he's going to read the affidavit by Mr. Nsebeza as if it's evidence tendered? Or I see that Ms. Suka hasn't been excused. Is that going to be done through Ms. Suka? I'm trying to understand.
Sorry, Ms. Moroka. Ms. Moroka?
I thought you'd heard me. I was saying I still don't understand. Is Mr.
Yes,
Vani?
that's because you've not been here. We've previously been informed that Mr. Nsebeza, who was due to give evidence after Ms. Suka, is not in a position to do so as he is ill.
No, that I understand, Madam Chair.
Yes.
I understand that Mr. Nsebeza is indisposed. What I'm trying to understand is what does Mr. Vani want to do now, today?
Yes.
To read his affidavit, which is part of the record, or what does he intend doing? Doing it through Ms. Suka or doing it himself? I don't understand that process.
Chair.
Thank you.
Chair.
Mr. Siminya?
This being an inquisitorial forum and process, the rules tell us without doubt that the strict adherence to laws and rules of evidence don't apply. If Mr. Nsebeza is indisposed throughout, we intend to read the content of that affidavit into the record. What cogency they may carry ultimately is a matter for argument.
Yes, thank you.
When Mr. Siminya says we, what's he talking about?
Meaning the evidence leaders.
To understand, Chair. And I don't know why Mr. Siminya is getting worked up about it. All I want to know is what is the process that's going to happen today so that we understand it.
Yes.
I don't understand what
Ms.
Mr.
Moroka,
Vani
I still
means.
have to rule on Mr. Vani's request.
That, Chair, all I wanted to do was to understand what's going to happen.
Yes.
Chair, perhaps before you rule, if I could respond. To save time, I don't intend to read all three affidavits into the record. I will simply paraphrase, draw the Commission's attention to matters we think it should pursue further. And there will be certain paragraphs that I think are important, which I will read verbatim, but there won't be that many of them.
Yes. Mr.
And we won't do
Vani,
this through Ms. Suka.
Mr.
She
Vani,
can be
I
excused.
think Ms. Suka is still giving her evidence, and we are still dealing with her testimony. We've got to excuse her first before we can attend to you.
Yes, agreed, Chairperson.
Yes. Ms. Suka, we profoundly thank you for having made time to come and give evidence to this commission, which we think will greatly assist the commission in discharging its function. We know you have a hectic schedule, but you made sure that you made time to come and give evidence. For that, we thank you. You are excused as a witness.
Thank you, Chair.
You may be called again to be cross-examined in due course.
Thank you, Chair.
Thank you. Mr. Vani?
As the Commission pleases. Chair, can I assume that you have ruled on the matter and I may proceed?
Yes, no, I haven't. I haven't. I thought you had indicated that you don't know the condition of Mr. Nzebeza right now.
He is presently undergoing treatment.
Yes.
He's indicated he's in no position to testify while he is being treated, and that he would have to assess his condition at the end of the treatment.
Yes. Shouldn't we wait until that assessment has been done?
Chair, the only issue is that could be weeks or months away. The Commission might have concluded its work by the time his treatment is done. It's an open question.
Yes. Are you not in a position to assess that by Friday?
Chair, I did speak to him yesterday, and he said that within the near future, he's not in a position to testify, and certainly not this week. And at the point where his treatment comes to an end, and he's in the hands of his medical team in that regard.
Mr. Vani, we are of the view that it's too soon to decide to place his evidence on record now. We'll have to defer it until next week to assess what his position is.
As the Commission pleases.
Yes. That being the order of the day, we are adjourned until tomorrow at 9 o'clock.
As the Commission pleases.